The things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, welcome to the show. Today, our topic is check all the boxes, what your real estate contract needs. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like. Make sure to subscribe to our channel. You can find us on Facebook, and you can find us on YouTube. On YouTube, we are at NREM Podcast. That is at NREM Podcast. Make sure to go and subscribe. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So continuing with our What If series, I will talk today about what if a seller dies after a purchase contract is signed, but before escrow closes. So you have a signed purchase contract, the seller dies, what happens in that case? And basically what happens is you have a binding and enforceable purchase contract, and it's binding and enforceable against the seller's estate. And a probate will need to happen whereby a personal representative, as we refer to them in Arizona, or other states call them executors, they will need to be appointed by the court to basically have the power to perform the remaining portions of the purchase in the place of the seller. So once they're appointed by the court enters letters of appointment or letters testamentary. There's other verbiage, but it's basically, we call them the letters. The court issues the letters, and that then gives the executor or the personal representative the power to move forward and close on the sale of the property and convey title of that property to the buyer. Now, if there is a situation where the personal representative or executor refuses to close and perform those functions, then the buyer can go into probate court, petition the court, and ask the court order that the personal representative or executor close on the transaction so that the buyer can purchase the property. But the purchase contract doesn't go away because the seller passes away. Instead, it will be binding upon their successors, assigns, heirs, and they will have to then, the estate will have to then close on the transaction so that the buyer can purchase it and have title to that property.
All right. Thank you for the legal update. Sean, a few announcements for you, the listener. So our Creative Finance Collective, what used to be known as the Creative Finance Symposium, but the Creative Finance Collective, we're going to have, is going to be Wednesday, May 24th at 5:00 p.m. And on the collective with us for that episode, we have attorney Alan Seshker, aka the Rap Nerd and creator of Rap University. If you've watched our show before, you've seen Alan. He's been a guest. And he's really one of the go-to guys, if not the go-to guy, when it comes to raps and understanding the rap transaction. And as we said, he conducts the Rap University, which has an online version of it now. Sean, you've attended it. Maybe you could tell our listeners a little bit about that.
Yeah. So before the online version came out, he was offering the class or the course in person. It was a one-day course, and it was in different cities within Texas. I attended the one that was held in Dallas, and it was awesome. I learned a lot. about a quarter of it was based upon, Dallas law and using Dallas forms, but the rest was applicable basically across the board when you're doing what subject to or wrap transactions. Like you said, Andy, Alan is very knowledgeable in this area. In my view, one of the top, wrap attorneys nationally. He's, been doing it for years before it became even popular with today's market. I mean, he's been doing, wrap transactions and closing them as an attorney for forever. So it's definitely something that you should, if you have the chance, go online, register for, take, or if you can go in person, go travel to wherever he's offering it next and attend in person. But it's definitely something I, recommend for anyone wanting to do subject to transactions.
Yeah, and Alan will be, again, with us on May 24th at the Creative Finance Collective. And an important note about the collective is Alan's really not going to be there as a guest with us, but really as kind of a co-person or member of the collective to sit and discuss with us the wrap transaction and particulars with regard to subject to transactions. And that's the idea behind the collective. So what we're going to be doing is having a final chance for to do and talk about creative finance kind of this season. And we're going to take a break and we're going to be coming back in full with the Creative Finance Collective in July. And what that's going to be is a collection of lawyers from a variety of different states, professionals that are seeing creative finance and the laws of creative finance from different angles, and who are going to be there to discuss and give you, the viewer, the real estate investor, the listener, an opportunity to watch, to participate, and to ask questions all throughout, so that you can see really how the sausage is made and be a part of the process and get your questions answered. We're really excited about what that's going to look like, and fully rebranding and fully releasing that in July. So hope that you can be a part of it, and make sure to join us on May 24th at 5 p.m. Again, where we're talking with Alan Seschker about that. All right. For our episode today, one reminder is we are taking questions in the final 15 minutes of the episode, and we will be addressing some questions that were posted to us in some Facebook groups along the way. And so we'll be answering questions that you, the listeners, have posted there as well. But if you have questions, I'm going to turn it over to Mayu, who can give you an idea how to go about posting those and being ready for that segment.
Thank you, Andy. And happy Tuesday, everybody. Thank you for joining us again live on the InRem podcast. If you've joined us before, you know how this works. We do take questions live on the show. So whether you're watching from our Facebook pages or from YouTube, we are monitoring the chat for your questions. So we usually take the last 10 to 15 minutes of the show. If you have a good question based on our topic today, which is what your real estate contract needs, then go ahead and drop it in the chat. We take questions in order of priority. So if you do have a good one, make sure to leave it as soon as you get the good idea in your mind, and we'll try to get them all at the end. So let's get into it.
All right. Thank you, Mayu. Yeah, make sure to leave your questions now as you think about them. All right, we're going to get into our topic today, which is check all the boxes what your real estate contract needs. So we're going to get into the details and the weeds of the real estate contract. And with us to discuss all of that and that topic is Paul and Adam Vincent, attorneys with Vincent Esquire out of Ohio. Paul and Adam, thanks so much for joining us, guys.
Yeah, thanks for having us. It'll be less boring now that Adam's here.
Hey, well, no promises.
But yeah, guys,
thanks for having us.
We have been waiting with bated breath for the other half of the Vincent plan. The audience has spoken; they demanded it, and
now you guys are just making fun of me. I get it.
Now it's mocking. Now it is mockery. It's not good.
Thanks a lot though for having me. Appreciate it.
Yeah, we're super happy to have us. So, Paul and Adam, tell us about Vincent Esquire Attorneys, about the firm and what you guys do.
Sure, Adam, you want me to ramble on here? Sure.
Please,
So we're based out of Cleveland, Ohio. Day to day, we help entrepreneurs solve problems that comes via syndication. If you need to, close deals that you can't afford yourself, we help people with that. We obviously help people buy and sell assets, whether it be commercial deals or businesses. We help with all that. And then we help people who accumulate things, what to do with those with some estate planning. So those are kind of the three-legged chair that we deal with every day. And then we have some other things we do outside of just being lawyers. We have a private Facebook group called the Deal Structure Crew. We kicked off a month ago this little fund that we're going to hopefully help people close seller finance deals with. And I think that's it. Adam, was there anything else I'm forgetting here?
You did great. I would just add as part of that, and it deals with our conversation today, is just with contracts, we help folks negotiate when things don't go as planned. And so that involves looking at a contract, the one involved, and figuring out what the situation is, how much leverage either party has based on that contract. And we'll talk about the important things with that. But really, that's what everybody wants to say. Well, is this a contract that'll stand up, or is this the one that's going to always win? It's like, well, how many boxes does it check in terms of creating negotiating leverage with the other side if things don't go as planned? So we'll talk more about that. But I'd say just day to day, that's a big part of it, is just helping problem solve and resolve problems when they arise.
Talk to us a little bit about the fund that you mentioned. I think I've seen on social media some posts about it, but what is it? What does it have a title or a name, and kind of how does it operate?
Yeah, so it's called Sidekick Capital. What we see often are people who have this great seller finance deal, right? They're like, oh, the guy's going to carry XYZ, 40% of the purchase price, and yippee, he's willing to sign. Well, then they're using bank financing, and they're like, hey, I got this seller that's got this real sweet piece of paper, and that should count as the equity to close the deal. Well, banks don't give an S about paper, right? They want real cash. So one of the things that we'll solve is for points be the equity on that. So we'll lend the money, close that loan, and get it back. So that's one. Obviously, double closing. If you want to keep the assignment under wraps, we do the double close. And last is EMD. So if you need EMD, a lot of people are giving up equity in their deal for earnest money deposits on commercial deals. We will just take some points and put that money up. And there's some things to do with the contract to protect our money and our funds and our investors' money on that. But yeah, those are the three things we're kind of focusing on those deals. And it's up and running, getting a lot of interest. The thing that takes a little time is getting the deals in, right? So the investor is very excited. It's just now we need some deals to fund. So
very cool.
Yeah, pretty good.
Now
let me one more thing, more pat we got to put on here, because we're restarting, and it'd be great if you guys were willing to come on. We're starting our own podcast called Here's the Deal, and we started for about, I think, 6 months or so. Pandemic happened. We got sick of looking at each other during that time, and we went on a hiatus. But we're bringing it back, and we'd be flattered if you guys showed up for that.
Yeah,
absolutely.
That would be great. Where can listeners find that? Is it going to be a
no clue? We're gonna read, we have some old stuff, but it's like, just a couple of clowns that kind of edited together. Like, we really want to make a nice one, like you guys having that video. For some reason I showed up on there, but
a lot.
we want to make sure it's well produced and worth listening to. So we're starting from zero. So.
Well, that's super exciting. Can't wait to see how that plays out, and we'll happy to give you any tips along the way, what worked or what doesn't. But that cool idea. Can't wait to see more of that. So you guys focus pretty heavily on commercial real estate deals, I think, as opposed to residential deals, and I think that's probably pretty common in a lot of states with lawyers. The same is true, though. Sean does a lot of creative finance work with investors that are into residential real estate. Most conventional transactions, though, in our state happen with title companies, so lawyers are often not in it. But doing that, you guys do commercial, and we're going to get into the real estate purchase contract. Let's get into some of the real major differences for our listener between the commercial and the residential contract, because I think there are pretty significant differences in what leads up to closing, how it's formalized and finalized, so on and so forth. So why don't you guys explain some of the key differences between the residential and the commercial contract?
Yeah, for sure. If you've never been through the rodeo before, it is black and white different than residential. I would say, this kind of ties back to what you mentioned a second ago. The first and foremost is that there's actually lawyers involved in almost all commercial deals. Now, there's plenty that don't, but I'd say the great majority do have attorneys on that side, which is unusual. On the residential side, it's a lot of, agents going back and forth and talking on cell phones and getting it done, on a weekend. But on the commercial side, first and foremost, for me, at least I would say, is that usually both sides have lawyers, because this contract ends up kind of going back and forth a number of times before it's really ready for signatures. What else, Adam?
Yeah, no, I think that's the big thing, is that there's more negotiation, more things to negotiate outside of price, obviously, which is a big thing in residential. And a lot of the details, like due diligence, and depending on the type of asset, environmental and other things like that you might have to negotiate through in closing, and how long you need for that due diligence, depending on the type of deal. So I think those are some of the big ones. Just a few more levers that have to get negotiated in commercial than in residential usually.
And you mentioned due diligence, which in my experience, that is a major difference between the residential and the commercial, both the contract and the transaction itself. What kind of things are you thinking about in a due diligence provision in a commercial contract that maybe you're not thinking about in a residential?
Yeah, no, that's a real good question. So days to visit, obviously that kind of goes both ways, but that's an important thing to think about is when can we actually do it? Another thing that's always in contracts, but I'm not sure any seller ever really looks into, is that the buyer actually has to be insured for the visit, right? Like, hey, you're not allowed to show up here unless you have, $1 million worth of liability insurance. Have I ever had any? We did have one time, like we do a lot of these, but we did have one seller was like, hey, send your insurance. And the buyer was like, what? They'd never heard that. I told him, I was like, look, this is probably in every contract you've ever signed, but no one ever asked for it. It ended up being just like all the other ones. The seller was like, screw it. You can come anyway. But that's an important one. There's like sometimes the jerky negotiations can happen very early too. Like one being, a lot of contracts say, hey, I want all the leases, right? And then the seller will be a dick. Are we allowed to swear on this? I don't know, too late. And they don't want, they're like, oh yeah, sure. You just got to come to the office. They're all in paper. It's like that sort of stupid back and forth due diligence kind of common sense stuff happens. But those are the first kind of big difference makers that pop out to me. What about you, Adam?
Yeah. Well, and you're talking about due diligence, what is it that you need? That's dependent again on the type of asset, but usually ours is broken up into financial information, spreadsheets, if it's a multifamily, rent rolls, those sort of things. Some legal things dealing with the history of the property and how it's currently held, and those sort of things you usually ask for. And then some more details about the property. If they have like old surveys, they have other drawings and those sort of things. So usually broken up into kind of categories. And then, like you said, Paul, the timeline's very important. And then also, how long you get to visit and how that's going to happen, and what kind of notice you need in order to get on the property, and how they're going to provide that information. Is the other thing. Like you said, Paul, try to get in there. That's all going to be provided electronically, or whatever is necessary and easiest for the parties.
Yeah. And one more thing is, like, your due diligence really for the residential is like, hey, I'm going to come in the next 10 days to send an inspector, and they're going to basically do my due diligence for me, right? Is this place going to fall down? Is the basement, underwater before I arrive? And the commercial side, it's very important. It's great that you have a huge list, right? Like our due diligence list. And if anybody needs a due diligence list for commercial, like we can send it to you guys and you can, give it to listeners, whatever. If you don't pay attention to getting all that, one of the things we always try to get in our contracts is that due diligence doesn't start until you say yay or nay to this giant list. So if you don't have it, that's okay. Tell us you don't have it. But our due diligence timeline starts when you say yes or no, and then you send it to us. And that's when it does. Now, some sellers are like, hey, that's unfair. But you just go back and say, hey, it seems fair to me. Like we're interested in getting this thing done. If we have 30 days due diligence and you send us this stuff, trickled in over 21 of those days, it's going to make this whole thing kind of a mess. So important to not only ask for a bunch of stuff, but pay attention to every single item. Make sure they either send it to you or tell you they don't have it, so you're fully aware of what you're actually buying.
Yeah. And just to elaborate on that, our list that we use, and that's the most efficient for everybody involved, is it's a list of items, but it also has boxes. It's a table that say that they have provided it or will provide it, or it doesn't exist. So at least then you document all those things concerning each item, and you at least get it in writing. And again, that goes back to like leverage. If later on turns out they were fibbing a bit on whether or not they had information that might have been not what they wanted to hand over, you have it on paper, and it just helps you negotiating. Whether it actually gets you anything is another question. But that's what we like seeing and working with other lawyers and negotiating is, let's cut to the chase and not cut out as much chaos as we can, because it is long. It can get cumbersome. So put it in a table, and then you can at least look at it and say, okay, here's what they have, here's what they don't have. And then that's when, like Paul said, you can check off and say, okay, due diligence has been provided. And then the contract will call for giving notice that you accept that due diligence as is. And that'll start the clock.
Now, if you're a investor that invests in residential real estate, you decide to jump into commercial, I think one thing about the process that's really going to stand out, and that you're not going to be prepared for until you really do it, is the title review and the process of objecting to, or doing title objections.
Right.
Could you explain that process, what that looks like, and what's important about it?
Sure. Yeah. I mean, when you get the title of an asset that's been owned by one person for 20 years, you're going to probably see some hair on it, some part on the schedule that's like, what is this? And that's your chance to be like, hey, what is this? Why don't you explain it to me? As a buyer, the important thing is when you send it over to your lender, if you're going to do lending, right, is they're going to have kind of their own concerns, and your concerns are going to be pretty well aligned with the banker's concerns, although a little different. But yeah, so when you get another important reason on why to have an attorney, because if you don't have an attorney helping you out, when you get this set of potential issues, a lot of them aren't, but a lot of weird, things that show up on there, you need someone to look it over and explain whether or not it's worth the risk, or whether or not you need to bail on the deal, or whether or not, the seller can actually clean that up. So those are the important things. On a residential deal, right, there could be an IRS tax lien that's going to survive the transaction for a little while. That's concerning, but outside of that, most things are going to get cleaned up. But if you have some easement for a neighbor, that's been parking their dumpster there just in the summer, which happens to be not the time you're on the site visiting the thing, it's definitely stuff to be careful of, and it's gonna make an impact on the value of the asset. So.
Well, how does a survey fit into all of that? You mentioned an easement, and the neighbor parking a vehicle there and utilizing it at different times. When would a buyer want to obtain a survey?
Yeah, so really, most people only get a survey if the bank requires it. So that is 99 out of 100 times. Most buyers are like, look, if this has been an apartment complex for, any number of years, and there's been no city objection to its use under that, then we don't really care about a survey. I see surveys happening more often on the mobile home park side of things. If you're buying a building, right, you're buying a 100-unit apartment building, it's pretty clear on what's what. But if you're buying a mobile home park with kind of undefined land, right, and people just could potentially park their mobile home, somewhere else on the lot, that's somewhere that I would recommend people doing it. RV parks, kind of the same idea, because you really want to make sure that you're buying what you think you're buying, and not all the way over to the lake. Well, that is actually owned by, Mr. or Mrs. somebody else who's now going to be in your ear to get out of here. So.
Yeah, and just to jump on that, and also title, they kind of relate. Sometimes there are some unusual things where a property is split into two parcels, right, for some reason, just because it was two parcels, and then they just built kind of across the line. That came to mind also on title, because then there's also Paul mentioned lenders are going to have their policy, and that covers a lot of the issues that come up in title. But there are also things called an owner's policy that cover different things that the bank isn't going to have under the lender's policy. And so just know that that's a thing. That's important. People know that it's a thing just in the scenarios where you do have something unusual, like that parcel split. That's where that owner's policy could come into play and be something you need.
Yeah, I've done a little bit of commercial work related to like vacant land and even some retail space. And the things that we come up on when we do get a survey is there's a lot of encroachment issues that we always find on those things, because especially with vacant land, you don't know where the boundaries are always. And so, neighbors are building on neighbors. How would you handle that in the commercial setting? You're representing a buyer, you're doing due diligence, and all of a sudden you get this survey and you realize, oh, the neighbor has put their, fence 3 feet onto, the buyer's soon to be buyer's property. How would you handle that as part of the title objection process?
Yeah, it'd be basically, what can we get resolved, or do you want to take on the known risk? Probably not a good idea to just show up and bulldoze the fence. You might want to, but and a lot of times it's going to come back to retrading. Like, okay, it is a known risk, but I want some discount because of that known risk, right? I'm losing.
Mm-hmm.
Maybe it's not important property, right? It eats into your common area that no one would ever really notice because it's 3 feet. I think it just comes down to being educated, entering into these things, well educated. If for not, especially if after close you find out and now you're upset about it, it's like, well, too bad that ship has sailed, right? So I think you try to retrade if it has some value. If it doesn't have value, just comes down to whether or not you want to take that on. So
talk to us about the environmental concerns associated with a commercial transaction. I don't remember when I first started doing my first ones as a young lawyer, learning things like the phase 1 environmental and the implications involved in that. Why don't you talk to our listeners about that?
Yeah, Adam, I talk a lot. You want to talk?
Sure. Yeah. No. So that's just something that's going to reveal. It's depends on the different assets you're getting, especially gas stations, dry cleaners. Those are the ones that are big problems.
Unfinanceable.
Yeah, and but depending if you're near water source and those sort of things and some other unknowns, you might get an environmental. A lot of times, if it's a functioning asset in commercial real estate, which usually they are, they're relatively stable environmentally. But yeah, you do the phase 1. If that turns up anything, in your contract, you should have the ability to get a phase 2 if you're the buyer, and then the terms and timeline for doing that and getting that as part of your contingency or within the due diligence period taken care of, so you can again be educated as you're going into it.
And if you don't do it, there's nothing that says that you have to do the phase 1, but if you don't, and there's a major environmental problem, you inherit the problem, right? And
absolutely.
My understanding is sometimes you're dealing with the EPA at that point, and the fix that they might impose.
It's
significantly
expensive.
cost prohibitive.
Absolutely. I actually had a guy. So there's an eminent domain deal in Cleveland. We had a big freeway that went through kind of a somewhat dilapidated part of the eastern side of Cleveland, and all sorts of people rang the register because they're like, oh, I once owned this turd, but I just got a couple $100K because that's how it works when you have eminent domain sometimes. Well, I had this one guy that was just like, I want to make this land more viable because he knew the eminent domain was coming, and the state was cutting checks coming down the road. Well, before they got to he's like, I'm just going to go bulldoze this old building. Well, he bulldozed the building, didn't get the permit, all that stuff. And it became very expensive, like almost $1 million of the EPA cleanup. Now they have to take the entire kind of crumbled, build
pile of asbestos.
Yeah, just a giant pile of asbestos. So although his check would have been a big one, it ended up having to go to our friends at the U.S. government. So yeah, you got to be careful. It's serious stuff.
And if it's an old property, people did used to bury lots of things, and I mean, tanks are the most obvious thing that no one knows is down there. But there was a time when before garbage dumps were as common as they are today, and people just took them out back.
There's a city near Cleveland that I won't get into the name of the city. I mean, it doesn't matter. It doesn't take long to find out. But they're building a new police station, digging up here we go, breaking ground. 2 weeks later, find like dumpsters and dumpsters and dumpsters worth of like household items, and that's what happened. You would make a little garbage dump and cover it with dirt, and then put grass over top of it. And now our police station, we had the EPA, we had to fix that problem, and now our soccer fields have the same under there, and that's why we can't really dig in, because we don't have to deal with that problem. So it's a funny world 50, 100 years ago, for sure.
So explain to us one final difference between the residential and the commercial contract. Explain to us the difference in the negotiation process. Specifically, I'm thinking of what's unique to the commercial transaction, which is the letter of intent. Why don't you walk us through that process?
Yeah, I'm gonna go over.
Sure, I'll take that. Letter of intent is just that. It's a letter. Most often they say they're non-binding. That can become an issue if it's not made clear within the letter. Usually literally takes the form of a letter and has the major bullet points that would be in a contract, and says essentially within 10 days of execution, or however long execution by both parties, buyer or seller will provide a PSA agreement, a more formal contract. So the LOI kind of just opens the door to negotiations between the parties, because there are a few more moving parts. In commercial, isn't commonly call up other agent and give them a price, and that's that. Commercial involves a little more, so we put it into a letter rather than a quick phone call that sometimes happens and works for residential. And again, that's usually not binding unless one party leads the other party on, and money is spent, or those sort of things that might create a binding contract. And that can happen in those sort of scenarios where one party's relied on the other party's kind of promises. But it's a non-binding thing just to get the negotiations started, and at least get the parties moving toward a formal contract.
Yeah, and I would just say it kind of sets the expectation for both sides, where it's like, hey, if Paul's buying your deal, then maybe I need 90 days due diligence or whatever, and then maybe if Adam was to do a letter of intent, it's like, I only need 30 days due diligence, and I'll give you XYZ cash as EMD, and I'll close within 30 days after that. Just kind of sets the expectations, because if you do all your puffery and try to impress a broker or a seller that you're going to close this deal in 30 days, and then you put the contract together, and then either have new terms that weren't in the LOI, or you don't get to those 30 days, it will make you look like a clown. So you want to make sure you're being honest in that LOI. You want to make sure to lay out as best you can the important stuff: price, like Adam said, due diligence, EMD, and kind of extensions if you need that, like what value you're given for that. And I think the other important thing in that is that a lot of that happens without the lawyers involved, the LOI, because those are like 5 to 10 important things, and then the lawyer comes in when you're doing the more formal purchase and sale agreement that has all the other exciting stuff like environmental concerns and title concerns and how to resolve all that. So
yep. And just to reiterate, make sure it's achievable. Like Paul said, timeline wise is a big one. Also, avoid making it too appealing of a deal that it's again not achievable. For example, if you say you have non-refundable EMD, but then you're like, well, what if sometimes they put that in the LOI that it's not refundable, except you literally don't know anything.
Right. Yeah.
Yeah. And buyers at that point, you really know almost nothing about properties unless you have some connection to it, right? So that becomes kind of a risky thing to promise. And then when the formal PSA comes around, you're like, wait a minute, I don't know anything about this property, and I'm handing over money I'll never get back.
Except the financial contingency, the environmental contingency, so right. Don't look like a clown.
Yeah. Yeah.
So let's break down some important provisions in the commercial purchase contract. Sean and I have kind of compiled a list of ones we think are important, but we want to get your take on them. And we don't want to know if you disagree with us. We only want to know if you agree with us.
Only tell us that we're hard.
Yeah, we want to get your take on these provisions, and then anything else you think is important beyond that. The first one we thought of, obviously, the due diligence period, the inspection period is important because usually we're dealing with earnest money that is going to go hard at some point, and people don't want to lose that if there's a problem. One of the first ones we thought of was cancellation for any reason during an inspection period. What are your thoughts on that? And are there additional items you'd want to add to that?
You want to if you want that EMD back, you need to make it as crystal clear as possible. If you're making it a financing contingency, right, then it's like, well, what does that really mean? Like, how many banks did you go to? How long were you working with that bank? How many other deals have you done where you really could get financing, right? So you need to have this, I can cancel for any reason or no reason at all. Now, a seller is going to object to that. They don't like that, right? But you should definitely have it in there, because you don't want a title company who is not going to pick a side. They may feel like your friend because you wired them the money. They're not. They need both sides to agree for that money to be released and the deal to die. So you want to make sure that reason to cancel this thing is crystal clear, is black and white, that you can cancel for any reason during a set period of time. And then you better stick to that set period of time, because if you're negligent on hitting your timelines, a seller doesn't care. I had a deal where a buyer lost about $525, I think, in extensions and extensions and extensions, and hoping to fix a problem. And then there was maybe the third one, maybe the second one, but the seller was just like, no, thanks, and then they just kept the money, and there's nothing to do. It's like, you're outside the timelines, black and white, and real bummer.
Yep. And I'd say absolutely did great on the first one. Totally agree.
There you go.
Well, that was always the stressful thing, I thought. Sean, we get your take too on this. Was the deadlines in commercial deals, especially when you've hired the lawyer. If you have to be Johnny on the spot and not only calendaring those deadlines to know when they come up, but to make sure you meet them, because it feels like malpractice is so easy to have happen if you let any one of those deadlines run, because they can hold you to it.
No, yeah, it's a well-drafted PSA too makes it real clear, just like that. Like, hey, you need to get rid of it on May 16th at 5 p.m., and it's 5 p.m. Eastern. It's not, you crazy people out in Pacific, or Mountain Zone. so yeah, got to be real careful, that's for sure. But that's probably I think the most important one is from the outset. And I understand too, anyone that's never done a commercial deal, you're going to come out of pocket, right? If you go and see a residential property, your agent may eventually hate you for all the time you're wasting for them, but it doesn't really cost you too much. Mm-hmm. On the commercial side, you're going to spend money once you get through the LOI. A lot of people do those LOIs on their own, but once you get a lawyer involved, it starts to pile up.
And the earnest money is not small on commercial. It's not like 2,500, $5,000 even. I mean, you're talking tens, if not hundreds of thousands of dollars in earnest money that,
is pretty common. Down. Yeah, common for 1%, but sellers will ask for more just to kind of prove whether or not you got,
right,
a wallet to do it.
So let's talk about provisions relating to the title objection process. I know that can be deadline laden as well when you make your objections and everything else. What do you think is important transactionally to plan for in that?
Yeah, I'll just do that one real quick. So you need to have a specific time when you're going to get title to you for review, you and your counsel to review, and then make sure you have a drop dead deadline to present those objections. And usually it's about a week or 10 days after you get it, so you can review it and send it back. Nobody wants to waste their time. So if you get it back and it turns out, that parking lot that they don't actually own, it's owned by the city, but they're collecting rent from tenants from that, and you're not willing to take that on, you want to cancel that contract as soon as you can. So like all commercial things, deadlines are important. You want to make sure that the law firm you're working with is going to help you stay on top of those and get those things responded to, or at least making an addendum if that's what's necessary. But yeah, timelines are everything, and the same with title objections.
So all of these contracts have all had force majeure provisions, and they've had them since before we were all lawyers, and we never got into them. And then a couple years ago, this thing called COVID happened. And for the first time, everybody started to think about
Yeah.
A force majeure clause. Have how you approach those changed given what happened in 2020 with COVID? Have you suggested alterations, or has your form contract changed with regard to that, or was it sufficient to deal with what we went through?
Depending on who you ask, right? Someone may say that COVID was not God created, right? So you want to just include that, be specific about it. The other thing I was actually talking to somebody recently about was the period in time that you're buying a single family home, but in that period of time, the city that you plan on Airbnb is now outlawing that. And is that going to be a reason enough that you can cancel that contract? Because, there's a lot of cities. It was more so 2 or 3 or 4 years ago that cities were decidedly against Airbnbs and short-term rentals in their jurisdiction. But I'm sure many cities have that one bad Airbnb that ends up ruining it for everybody. So that's something I've never had to deal with, but I was actually talking to somebody about that the other day. Is, hey, what, you include that? It's almost like a force majeure, but it's instead of God, it's the city council or whatever.
The local government guy.
Yeah, that's right. But that's, you want to be specific, especially with COVID. You may as well mention it because then you can use it later.
Yeah, and I also just think these are becoming more important as well because of the extreme weather. We're starting to see and people building in places they wouldn't have built in previous decades, right? So coastal building is up. That means triggering these terms are going to become more common going forward. So they're important for sure, even if they're kind of skipped over for most times.
Yeah.
What about the representations and warranties of the seller? I find that I do a good bit of small to medium-sized business mergers and acquisitions, and I always see this come up in those contracts on representations and warranties, but the client they just like skim past that. Mm-hmm. And, they're going to the meat of the contract, like what's the price? And am I getting the price I agreed to and all that stuff? And they skip past that clause that says I represent promise and all of these things, and they think that that's just good. And I'm like, man, that is so important. How important is that, and what are you guys looking for in seller representations and warranties?
One of the things you're looking for is who's making that rep and who are they responsible for in terms of the knowledge that they have. So you're asking them to tell you about the property, to provide the information about it. And does that include the agents of seller? And does that include, third-party management and that sort of thing? So I think that's one important thing. Sellers are going to want to say it's only actual knowledge only of the seller, entity or individual, his or herself. And obviously, if you're a buyer, you want the entire crew on the hook, as many people as possible, so that you're getting the full amount of information and you're getting those reps and warranties from those folks, from all the folks, rather than just one limited person and their limited knowledge there. So that's one thing that comes to mind right off the bat when you're looking at those.
Yep.
That's good, because I never think about that. I mean, you put a seller's representation and warranties in there, but when it's an LLC or a corporation, I never even would have thought, oh, well, let's make sure that we're going through the list
all
of
their affiliates.
Yeah.
Especially if it's owned by an investor who lives on the other side of the country and they just hire other, they have a staff maybe, but usually it's third parties and those sort of things. So,
and I'll just add in there's a really important part of a buy and sell on any size, any decent sized deal is just like the relationship to the seller and, between the parties, whether it's brokers or amongst actually the owners and the potential owner. Is like, you got to, try to spend time with these people, because your gut can be right a lot of times, right? Show up to the property, spend the time that you need to at the property, talk to people at the property if you can, without getting yourself in trouble. But like, we've had a lot of deals go sideways just because people are like, I didn't get a good feeling about the person, and there's real value to that. And it's worth listening to if your gut tells you to bail.
Yeah, along those lines. Go ahead. Oh, reps and warranties. Sorry, just along those lines. It's sort of what I mentioned before. Is those are helpful, but they're mostly a leveraging tool later on if things don't go as planned or a surprise comes up or whatever. And so that's really where it comes into play is you want to get as much of that on paper. So if down the line things don't go as planned, or you find out not everything was disclosed and that sort of thing, you have something to negotiate based on. And like Paul said, ultimately kind of getting a sense of the other side and the party you're working with is one thing that I think should happen, even if it's not on paper and formal. I think that's definitely something that's important in these transactions, getting a sense of how this property was run and the outfit that owns it and is selling it to you.
Similar to representations and warranties, and you just mentioned it, Adam, is the idea of disclosures, and there's a process for that for the seller disclosures. I'm curious to hear what's important. I know what you put in that will depend, or what you promote to put in that's going to depend on whether you represent the seller or the buyer, obviously. But regardless of how that's negotiated, do you generally kind of preach for the seller to just over disclose? I mean, just to be safe, don't just disclose everything, in other words?
Yeah, as a seller, you don't want kind of a late game reason for a buyer to back out who might, find out something small, but could be reason enough for them to be like, oh, flipping table about them missing a utility bill 1 month or something like that. So if you have anybody that's written you a letter, a tenant slip and fell, and you haven't heard much about it, but you got it. Yeah, you want to overshare. Similar to kind of our prior podcast about syndication, you want to disclose as much or anything as someone may want to know that would change their mind about the deal. So oversharing may be uncomfortable, but it's worth doing in the long run for sure.
Yeah, and realistically, it shouldn't upend the deal most times. And if it does, then be glad you shared it, because if they found out later on, you're in the middle of a headache, and they probably have good reason to be suing you if it's that big of a deal. If it's not that big of a deal, buyer's excited to buy this property if they can do the business, judgment on whether or not it's something that's going to stop the deal. But ultimately, you don't want to risk or buy yourself a lawsuit, right? So disclose that. The best closing is where you've given the buyer everything they need, and you're not risking having that liability hanging out there over your head and risking the other side coming back. Because unfortunately, the other side could come back, like Paul said, even if it's a minor thing, it might be enough for them to just be a real pain. So it's not necessarily that you're not disclosing like tanks or what'd you say, Paul, a garbage dump below the surface. Even if it's a minor thing, it might be enough for them to be a pain, even if they aren't going to win a lawsuit on that issue. If they're going to hold up closing or all those sort of things, that's the headache you don't want based on not failing to disclose some overshare there and avoid those risks and those headaches.
What about indemnification provisions? I know that's another one that kind of gets lost in the boilerplate of contracts, but they can be pretty important. And specifically, I'm thinking of like an indemnification provision by the seller for anything occurring prior to the closing, for instance. Any unique things that you think ought to be in those provisions that you see are often missing, or just something to always keep your eye on and make sure you've got it covered?
Yeah, I mean, fair commercial contracts are pretty reciprocal, right? So it's like, if buyer does something, indemnifies seller. Seller does something, indemnifies buyer, or prior to closing, or vice versa, right? Those are the big things. Other than making sure it's in there, you hope it's never needed, because whatever it is that you need indemnified for, paying lawyers will probably be more expensive than the actual indemnification itself. So but make sure it's in there. Make sure these things are reciprocal. Sometimes it's hard to catch that they are, and it's not just one-sided. There's some, I don't see it that often, maybe 1 or 2 out of 10, that it is a very one-side leaning contract. The majority of folks I work with, though, thankfully, it's, these provisions are reciprocal, where it's like, you protect me, I protect you, vice versa. So other than just make sure it's in there, I think that's the most important thing.
All right. We do have a few questions from the audience. Before we get into those, we wanted to address Questions that we got on Facebook, and Paul and Adam, if you've got answers to this, we'd be happy to hear yours as well. But Sean did a legal update last week regarding bankruptcy, and it was about bankruptcy in a creative finance transaction, or where a seller files bankruptcy in a creative finance transaction. We got some questions with regard to that. Sean, did you want to address that?
Yeah, so I think the questions revolved around, can you put certain provisions in your purchase contract that would avoid the repercussions of a seller filing for bankruptcy? And really the concern was, and surprisingly, there was a lot of, conversations regarding that topic when we posted the video, but the concern seems to be dealing with the statement that I made that if the bankruptcy is within the 90-day voidable preference period, that the trustee has pretty much full clawback ability to unwind that transaction. So you have to remember that the trustee is basically takes over the assets and becomes the owner of the assets. Their job is to find, money and assets that they can utilize for creditors and to pay their own bills. And the trustee gets paid from the assets of the estate. So the trustee's looking for assets. And so if they see a property that closed escrow, less than 90 days ago, where the property was worth $500,000 and the purchase price is $400,000, they're probably going to look to claw that back because they want that $100,000 in equity that's, out there. And if it's within that 90 days, the trustee basically unwinds everything. It's like the contract never even happened. They return whatever consideration the buyer paid. They put the buyer back into the status quo. They take the property back. It now becomes an asset of the estate. And then they go and sell the property for what they think it is worth. So the answer is there's nothing you can put in a contract or any of the related documents that's going to avoid that, because no matter what you do, the concept is the trustee can basically make it so that that contract never even happened. So no matter how, fancy the language is, how great the clause is, well, it's like the clause never even existed, because the trustee is going to say no contract, and they're going to claw that property back and, utilize it as an asset of the bankruptcy estate and make some money off of it. I mean, that's basically what you're looking at. The other question is, well, what about a seller who, hey, if a seller is going to file for bankruptcy, they knew that the bankruptcy was happening. And if they knew the bankruptcy was happening, isn't that, wrong or fraud or something like that? Well, let's assume that, they did enter into the contract knowing they were going to file for bankruptcy shortly thereafter and the risks that might be involved. Sure, you would have a fraud claim potentially against that seller. You could potentially file an adversary complaint, but that doesn't really do you any good, because your whole goal is to, have the asset, have the property. And so now you're pursuing a seller who is bankrupt and doesn't have anything.
Who has no
So,
money.
yeah, that doesn't do you much good. So bottom line is, when you do any real estate transaction, in a particular subject to transaction, if you go and you close on that thing and you still own it within that 90-day period, the trustee can go in and claw it back and bring it back into the seller's name or the estate of the name of the bankruptcy estate, as though that contract never even existed to begin with.
And maybe really the only thing you can do transactionally, which Sean discussed before, was to get the seller and then in the context of bankruptcy, the debtor, to agree to reaffirm the debt, which is an election that they do have in bankruptcy and something they can do. So in any event, Mayu, I know we have some questions for Paul and Adam. Let's turn to those.
All right, thank you. So now it's time for the show where we read your questions. We do have a couple today. One is a little bit longer, so bear with me. I'll try to paint the picture for you guys, and then I will turn it back over to you. So the first question, this one's a two-parter because it was pretty long. So this one says, I have a pre-foreclosure home under contract. The current owner married the previous owner, who was sent to prison 3 years ago. The mortgage is in his name, but his wife is the only name on the deed and also the power of attorney for the man who has the mortgage in ... to try to see if they'll... Okay, so his question is basically he wants to know if they'll agree to sell, or should I try to get the right paperwork and contracts in place and have her attempt to resume payments and do a sub 2? Let me see if there's a little more because I think some of that's missing. So basically the rest of the question is, should I try to get the right paperwork and contracts in place and have her attempt to resume payments and do a sub 2 deal? I'm under contract for $75K under appraisal price, so I really need to put this one together.
So let me jump in before we
No,
go.
make the commercial lawyers answer that.
Well, no.
The
This
answer is yes. That's
Yeah.
your answer. Yeah.
So I'm going to turn it over to them, but this is getting into specific legal advice, which
Right.
we obviously don't want to provide or give. But let's just talk high level, in generalities here about the idea of a husband and wife being married. The husband, has given the wife a POA. Could that POA be used, assuming that all things were done on the up and up? Could that POA be used by the wife to, if title will accept it, to, execute or convey a property or enter into a real estate transaction?
Yeah, if it's a broad POA, most of them say that, that it's for any issue concerning finances, and all of them usually include, bank accounts, mortgages, or real estate.
Transfer of property.
Yeah. So as long as it's one of the general ones, I suspect that it can. But this one is a lot going on. And by pre-foreclosure, is it just Liz Pendants has been filed, or is there an actual foreclosure filed? So a lot of questions. I think, like anybody that's watching this or listening to this and has a hairy deal like this, get somebody local, build that relationship off of your current issue, because you'll need that relationship later. So find a local lawyer comfortable with real estate, and they'll kind of walk you through some ideas. But you got a lot of work to go. So.
All right, Maya, did we have any other questions?
We do have one more question. So this one: how am I able to get a copy of the legal documents needed for sub 2? And can I adopt the form to my state, Pennsylvania and Delaware? Do you guys work with any attorneys in Pennsylvania or Delaware? Can you refer me to for creative transactions?
So we can handle that offline as well. As far as, documents for sub 2, whatever state you're going to be, doing a sub 2 transaction in, work with an attorney in that state who, understands the nature of that transaction and real estate to provide those documents to you. And as far as attorneys in Pennsylvania or Delaware, you can reach out to me, or even, I don't know, Adam and Paul, if you guys have referrals in those states. I know I have one, at least in Pennsylvania, that I can offer if they want to, the listener wants to reach out. I don't know in Delaware off the top of my head, but I'm always willing to hand out referrals to attorneys that are investor friendly. What about you guys?
Yeah, same. I don't know anybody for a sub 2 in either of those states, unfortunately. So.
Yeah.
All right. Go ahead. Paul and Adam, we really appreciate you being with us. Tell our listeners how they can, how best to find you.
Facebook's a great spot. We're on there. Obviously, VincentEsquire.com. If you have a deal you'd like to discuss about syndication, you can go to dealdiscussions.com, and that shows up our Calendly, and we can set up a call with that. But yeah, we're really pumped to have been invited onto your guys' show. Always fun. Even talking to lawyers, and it's fun, which is unusual. So yeah, we had a lot of fun.
When are you guys hoping to start the podcast?
We'll probably start recording, sometime in June or so. So we have like a little, jot form we can send if you guys want to join us, or we'll just email you and start figuring it out. But we are in the infancy rube stages of getting this thing going, so it won't be tomorrow for sure.
Well, folks, watch for that. I imagine it's at least going to be on Facebook because you guys are pretty involved. And
Yeah, we'll
interact on
we'll
Facebook.
fill the bandwidth for sure. It doesn't matter. Yeah.
Absolutely.
All right, guys. Thanks so much for being with us. Look forward to seeing you again.
Thanks, guys.
All
Thanks.
right.
Thanks a lot, guys. Appreciate it.
With that is our show for this week. Make sure to join us next week. We're talking about the American Dream, dealing with partition actions with our guest attorney, Nick Strom. We'll see you next week.
Have a good day, everyone.